administration. I asked OpenAI's ChatGPT how to use ChatGPT for contract administration. How can I use ChatGPT to assist in my job in contract administration? As a language model, ChatGPT can assist in contract administration in several ways. Contract review. You can use ChatGPT to review contracts and provide summaries of key provisions, including obligations, liabilities, and rights. This can help you to identify potential issues and to ensure that contracts comply with relevant laws and regulations. Contract drafting. You can use ChatGPT to draft contracts by providing answers to questions about contract terms, conditions, and clauses. ChatGPT can help you to ensure that contracts are written in clear and concise language and that they accurately reflect the parties' agreement. Contract negotiation. You can use ChatGPT to assist in contract negotiations by providing guidance on the meaning and interpretation of contract provisions and helping to identify potential points of contention. Contract management. You can use ChatGPT to assist with contract management by providing reminders of key obligations and deadlines, and by providing information on the status of contracts and their compliance with relevant laws and regulations. These are just a few ways that ChatGPT can assist in contract administration. By leveraging its ability to understand and respond to natural language, ChatGPT can help to streamline and automate many tasks in contract administration, freeing up time and resources for more strategic and high-value tasks. What is the character limit for me pasting in a contract for your review? The character limit for pasting in a contract for my review varies depending on the platform or interface you are using. However, it is generally recommended to keep the input length under 4,000 characters to ensure that the response is generated efficiently and accurately. If you have a longer contract, you can break it down into smaller sections for me to review one at a time. If you are using the OpenAI API, there may be specific character limits imposed by your plan, so you should consult the OpenAI documentation for more information. Why would it be helpful for a contract administrator to ask about obligations, liabilities, and rights under a contract or ensure that it complies with relevant laws? As a contract administrator, it is important to understand the obligations, liabilities, and rights of the parties under a contract in order to effectively manage and enforce the terms of the agreement. Obligations. By identifying the obligations of each party under a contract, the contract administrator can ensure that the parties are fulfilling their respective responsibilities and that the contract is being executed according to its terms. Liabilities. Understanding the liabilities of each party under a contract can help the contract administrator to manage risk and avoid disputes. For example, if a party is exposed to financial liability in the event of a breach, the contract administrator can take steps to minimize that risk. Rights. Knowing the rights of each party under a contract can help the contract administrator to enforce the agreement and ensure that the parties are able to receive the benefits to which they are entitled. Compliance with laws. Ensuring that a contract complies with relevant laws and regulations can help to minimize the risk of legal challenges and disputes. A contract administrator should be familiar with the laws and regulations that apply to the contract, such as those related to labor and employment, procurement, and intellectual property, and should ensure that the contract is in compliance with these laws. By identifying the obligations, liabilities, and rights of the parties under a contract and ensuring compliance with relevant laws and regulations, the contract administrator can help to ensure that the contract is executed effectively and efficiently, minimizing the risk of disputes and maximizing the benefits to the parties. What privacy, personal identification, and confidentiality measures should I take when submitting a contract for your review? When submitting a contract for my review, it is important to take privacy, personal identification, and confidentiality measures to protect sensitive information. Here are some steps you can take. Redact personal information. Remove any personal identification information, such as names, addresses, and social security numbers, before submitting the contract for review. Remove confidential information. If the contract contains confidential information, such as trade secrets or proprietary information, redact this information before submitting it for review. Encrypt the data. If you are sending the contract over the internet, consider using encryption to protect the information from unauthorized access. Limit access. Limit access to the contract to only those who need to review it and have the appropriate authorization. Consider legal requirements. Consider any legal requirements for privacy and confidentiality, such as those related to data protection and privacy laws, and ensure that you comply with these requirements. By taking these steps to protect personal identification information and confidential information, you can help to ensure that sensitive information is protected and that the privacy and confidentiality of the parties are maintained. Additionally, it's important to consult your company's specific privacy policies and data protection measures to determine what steps are necessary to comply with the organization's standards. If you review a draft contract, what kind of questions should I be asking? Contract terms, conditions, and clauses to make sure the agreement concisely reflects the agreement. When reviewing a draft contract, there are several key questions you should ask to ensure that the agreement accurately reflects the parties' agreement and protects their interests. Here are some of the key areas to consider. Objectives. What are the key objectives of the contract, and do the terms, conditions, and clauses of the agreement support these objectives? Obligations. What are the obligations of each party under the contract, and are they clearly defined and enforceable? Liabilities. What are the liabilities of each party under the contract, and are they clearly defined and acceptable to both parties? Rights. What are the rights of each party under the contract, and are they clearly defined and protected? Performance standards. Are the performance standards for each party under the contract clearly defined and achievable? Dispute resolution. How will disputes under the contract be resolved, and are the dispute resolution provisions acceptable to both parties? Termination. Under what circumstances can the contract be terminated, and are these provisions acceptable to both parties? Compliance with laws. Does the contract comply with relevant laws and regulations, and does it include provisions to address any potential legal challenges? Representations and warranties. Are the representations and warranties made by each party under the contract accurate and sufficient? By asking these questions and carefully reviewing the terms, conditions, and clauses of the agreement, you can help to ensure that the draft contract accurately reflects the parties' agreement and protects their interests. When I am reviewing responses on contracts, such as red lines or comments, can you give me an example what I would enter in ChatGPT, for example? The different versions of a term or the term and the comment in ChatGPT? Sure. Here is an example of how you could enter information about different versions of a term or a term and a comment into ChatGPT. Example 1. Comparing different versions of a term. Input. Can you explain the difference between the following two terms, confidential information and proprietary information? Example 2. Asking about a comment on a term. Input. Can you explain the significance of the following comment on the term confidential information? This definition is too broad and may limit our ability to use information we need for business purposes. How can ChatGPT help me with key obligations and deadlines, the status of contracts, and their compliance with relevant laws and regulations? ChatGPT cannot provide reminders, but it can provide information on key contractual obligations and deadlines, status of contracts, and regulatory compliance information in response to specific questions. Here are some examples of questions you can ask ChatGPT to receive information on these topics. Key contractual obligations and deadlines. You can ask ChatGPT for clarification on specific obligations or deadlines in a contract, such as asking for the due date of a deliverable or the specific requirements for reporting progress. Contract status. You can ask ChatGPT for information on the current status of a contract, such as the stage of negotiations, any key milestones that have been reached, or the status of any disputes. Regulatory compliance. You can ask ChatGPT for information on relevant laws and regulations that impact a contract, such as asking for clarification on specific reporting requirements or the consequences of noncompliance. By asking ChatGPT these types of questions, you can gain valuable insights and stay informed about key contractual obligations and deadlines, the status of contracts, and regulatory compliance issues. However, it's important to remember that the information provided by ChatGPT should not be relied upon as a substitute for professional legal advice. By edit confidential information out of a prime contract, could you identify the flowdowns for a subcontractor? As a language model, ChatGPT can provide information on the general concepts related to flowdowns and subcontracts. However, it cannot identify the specific flowdowns for a subcontractor as it does not have access to the actual contracts or any confidential information. In general, flowdowns are provisions from a prime contract that are passed down to a subcontractor to ensure that the subcontractor is aware of and complies with the requirements set forth by the prime contract. Flowdowns typically include clauses related to confidentiality, security, intellectual property, and compliance with regulations. To identify the flowdowns for a subcontractor, a contract administrator would typically need to review the prime contract and determine which provisions apply to the subcontractor. The administrator would then include these provisions in the subcontract agreement to ensure that the subcontractor is aware of and compliant with the requirements of the prime contract. In this case, if confidential information has been edited out of the prime contract, it is possible that the flowdowns related to that confidential information may also be edited out of the subcontract agreement. However, it is important to review the subcontract agreement to ensure that all relevant flowdowns are included and accurate. But I could provide section of the prime contract and sections of the subcontract, and you could identify the required flowdowns. Yes, that's correct. If you provide specific sections of the prime contract and sections of the subcontract, I can help you identify the required flowdowns. Please keep in mind that my answers are based on the information you provide and are not a substitute for professional legal advice. It's important to carefully review both the prime contract and the subcontract agreement to ensure that all required flowdowns are included and accurate. This can help to minimize the risk of disputes and ensure that all parties are aware of their obligations and liabilities under the agreement. Can you summarize the objectives of this employment contract in simple language, identify potential disadvantages for the employee, and provide points for employee to negotiate an advantage on these points? Employee contract template. Employment contract. This contract, dated on the day of in the year 20, is made between company name and employee name of city, state. This document constitutes an employment agreement. Deleted. In witness an agreement whereof the employer has executed this contract with due process through the authorization of official company agents and with the consent of the employee. Given here in writing, employee signature date, company official signature date. This employment contract is between company name and employee name and outlines the terms and conditions of their employment relationship. The employee is expected to perform their job duties to the best of their ability and comply with company policies. They will be compensated with a wage and may be eligible for benefits after a probationary period. The employment relationship can be terminated by either party with written notice. The employee must maintain confidentiality and cannot engage in work with competitors. The contract also includes provisions regarding non-competition, return of company property, legal authorization, and jurisdiction. Potential disadvantages for the employee include a probationary period with no access to paid time off or benefits, and the possibility of termination at any time without advance notice. The employee must also maintain confidentiality and avoid competition with the company. Points for the employee to negotiate include the length of the probationary period, paid time off policies, and the definition of confidential information. The employee may also want to negotiate compensation, benefits, and the terms of termination. How could the employee possibly convince the employer to reduce the length of probationary period, enhance time off benefits, and improve the terms of negotiation or terms of termination? The employee can try to negotiate with the employer to reduce the length of the probationary period, enhance time off benefits, and improve the terms of termination by providing a strong case for why they believe they will be a valuable addition to the company and why they would like to have access to benefits and paid time off sooner. Discussing their prior experience and skills and how these can contribute to the success of the company and asking for an earlier review of their performance. Outlining the current market trends and competitive benefits packages offered by other companies in the same industry. And asking the employer to consider making changes to keep the employee competitive and motivated. Proposing the length of notice required in case of termination and suggesting a compromise, such as a shorter notice period in exchange for a severance package. Offering to work with the employer to create a clear performance evaluation plan. And agreeing to regular performance reviews during the probationary period to demonstrate their commitment to the job and the company. It's important to approach these negotiations with a positive attitude and to be open to compromise and discussion with the employer. Do you have any concluding thoughts about ChatGPT and contract administrators or information I missed asking about? As a language model, ChatGPT can assist contract administrators by providing information and insights on various aspects of contract administration, such as contract review, interpretation of provisions, identification of points of contention, and compliance with relevant laws. However, it is important to keep in mind that the information provided by ChatGPT is not a substitute for professional legal advice and should not be relied upon as such. In conclusion, contract administration is a complex and multifaceted task that requires a thorough understanding of legal and regulatory requirements, as well as the specific terms and conditions of each agreement. ChatGPT can be a valuable resource for contract administrators, but it is just one tool in a larger arsenal of skills and knowledge that are required to effectively manage contracts.